Hearing the appeal, MD Sri Lanka against Secretary of State for the Home Department.
Before we start, I should make it clear that we're making an anonymity order to this effect, that no one shall publish or reveal the name or address of the appellant who is the subject of these proceedings, or publish or reveal any information which would be likely to lead to the identification of the appellant or any member of his family in connection with these proceedings. For anyone who's in doubt about the effect of this order, copies are available. Mr. Hussain.
My Lord, I'm very grateful. May it please the Court, I appear with Mr. Mackenzie and Miss Pickup for the appellant. My learned friends, Mr. Hall, Queen's Counsel, and Mr. Hayes appear for the Home Secretary. My Lord and my Lady, as you'll be aware, the issue raised in this appeal concerns eligibility for subsidiary protection under the Qualification Directive, and in particular the definition of serious harm for the purposes of Article 15b. The question is whether a person whose removal from the United Kingdom is prohibited by Article 3 of the European Convention on Human Rights, owing to inhuman and degrading treatment in the country of origin, namely past torture, giving rise to severe post-traumatic stress disorder, severe depression, and an extremely high risk of suicide, which cannot be adequately managed there, whether such a person is entitled to subsidiary protection status. My Lords, my Lady, it appears to be common ground that Sri Lanka has, and I'm quoting from my learned friend's case at paragraph 5.5, MS 87, it appears to be common ground that Sri Lanka has historic responsibility for the actions which caused the decline in the appellant's mental health state. That's 5.5 MS 87, common ground, at least it appears to be common ground, that Sri Lanka has historic responsibility for his decline. The battleground is whether that is irrelevant, as my learned friend submits, or, as we say, not only relevant, but dispositive in our favour.
And the point is the distinction between somebody who simply cannot be removed because of his Article 3 rights and somebody who qualifies for subsidiary protection under the directive.
My Lady, yes.
Brings with it benefits which do not come from simply the status of non-removability.
The qualification...
That's what the point of the case is.
The point, exactly, my Lady is absolutely right. The Qualification Directive is the first instrument anywhere, first supranational instrument, I should say, to confer a status with attendant rights on those who do not qualify for refugee status, but whose removal is prevented by certain international human rights obligations and indeed member state practices. And it's important to the appellant, and we've set it out for my lady's note since she raises it now, in our printed case at paragraphs 13 to 14,
13 and 14. Okay.
MS 57 to 58.
Thank you, yes.
And it's also in the SFI paragraph 31, MS 48. The rights which are important to the appellant are, first of all, family reunion under Article 23. Although his wife is here and has sought asylum, he can't sponsor her on discretionary leave. She wasn't here at the time of the inferior decisions.
Would you right to say those matters explain why this is important to him?
Yes.
Don't assist in determining the issue.
Certainly not.
And as to that,
Yes.
There's no doubt that he falls within Article 15 because his entitlement to Article 3 protection is enveloped within Article 15b, and so you come down to Article 2e.
Yes.
Which is what the case turns on.
Exactly.
Yeah.
My lady was simply asking what the point was.
Yes, why are we here, so to speak?
Why are we here? So it's family reunion.
So that people understand.
In particular, family reunion, and as far as domestic law is concerned, entitlement to a greater period of leave and faster eligibility for indefinite leave. Yeah. In the Qualification Directive, you also have a right, not an absolute right, as a subsidiary protection, person with subsidiary protection to a travel document under Article 25 and also a residence permit under Article 24. Those are tremendous innovations in the qualification directive as far as international law is concerned, and they are important to the principles of construction that we say apply. But returning to the common ground and the battleground, as I put it, we say that Sri Lankan responsibility for the appellant's predicament, present responsibility, we say, is transformative in this context. And responsibility arises because, first of all, the historic torture remains causally significant in his present predicament. See our case at paragraphs 42 to 44, MS 66 to 67. So it arises because of Sri Lankan historic torture, which remains causally significant. But it also arises, and this is not addressed at all by my learned friend, it also arises because the Sri Lankans have a present duty to rehabilitate him under international law. That follows from Article 14 of UNCAT. We address that in our case at paragraphs 45 to 46, MS 67. And breach of that duty to rehabilitate him as someone whom they tortured is a measure for which they may be held responsible and which exacerbates his suffering. That's the language of the ECHR case law. And as I say, Mr. Hall just doesn't engage with that at all. Why do we say that the issue of Sri Lankan responsibility is transformative for the purposes of Article 15b? Well, in parenthesis, we should note that the Advocate General in the important Bodge case held the same view. It's the key theme that runs through his opinion, and I'll take you to that opinion. But the key paragraphs, if my lords, my lady are interested, are 44, 49, 51, 58, 59, 65. It's the key thread running through his entire opinion, responsibility. But we say it's transformative for 5 reasons.
Can I just, I'm sorry to be
Not at all.
difficult, transformative meaning?
It transforms a health case from a case which is excluded from 15b to a case, call it a health case if you like, which is included.
Right, thank you very much.
Sorry,
That's all right.
The mere fact that somebody suffers from a serious health condition which will not be adequately treated in the country of destination is never enough.
Never enough.
Basically, certainly under the present case law. But you're saying the additional factor of the responsibility of the country of destination for the condition, in the health condition in which the person finds themselves, transforms the picture. That's your
Absolutely,
point.
my lady, yes.
Yeah.
And there are 5 reasons. The first reason is because, in light of its purpose, but we accept within limits, the qualification directive is to be broadly construed. I'll make short submissions on that. A broad construction. Secondly, perhaps more importantly, in terms of the Court of Justice's approach, in Bodge, home state responsibility means that there is relevant treatment in the home state or conduct in the home state. It means that the risk is not something to which the population is generally exposed. It means that protection or leave is not granted on compassionate or human rights grounds. And it engages what the court referred to as the rationale of international protection. And that's taken from its key paragraphs 35 to 37, those factors. That's the second reason why it's transformative. The third reason it's transformative is that because when the home state is responsible, the following Strasbourg principle is engaged. The principle is that the suffering which flows from naturally occurring illness, physical or mental, may be covered by Article 3, where it is or risks being exacerbated by treatment, whether flowing from detention conditions, expulsion wouldn't be enough here, I'll explain why, or other measures, and that's the key point, or other measures for which the authorities can be held responsible.
Right, risks being exacerbated by, just give me the list again.
By treatment,
Yeah.
whether flowing from conditions of detention, expulsion, or other measures for which the authorities can be held responsible.
That's the home state,
Yes.
authorities.
Yes.
Yeah.
And I'm sorry you've written it out. I should have said it's set out, if you want it, in our printed case at 38,
Yes.
MS 65.
We've got it verbatim, have we? Yes, thank you very much.
Sorry.
Yeah.
And it was first articulated
Pretty,
in
yeah.
Pretty, paragraph 52 of Pretty. It's been applied in many subsequent cases, including important Grand Chamber cases, MSS and Tarakel. And indeed, we'll see in the Advocate General's opinion that he referred to this verbatim, to this principle verbatim, at paragraph 44 of his opinion. If my lords, my lady want the reference, it's MS 947. And indeed, the court's exception to the healthcare exclusion, the court exempted certain health cases from exclusion. Those were cases where healthcare is intentionally denied. That itself is an application of this principle. The reason I say that is because it's clear that the denial itself needn't be the serious harm. It's enough if it causes or quote unquote exacerbates it. But that which makes the home state culpable, an intentional denial in the court in Imbodge, or a breach of duty, as in MSS, that need not itself be the serious harm. It's enough if it causes the serious harm or exacerbates it. The fourth reason, my lords, my lady, why we say that home state responsibility is transformative is because of the position under Article 3 of the ECHR. Now, my learned friend makes some, with great respect, surprising submissions on the relevance of Article 3 to 15b, which are based on, with great respect to him, selective quotation from Advocate General opinions and Travo. It's very clear that this provision was meant to track Article 3. In essence, it's not coterminous, yes, but it's meant to track Article 3 jurisprudence in essence. The Travo makes that very clear. The very opinion upon which he relies for the contrary position makes it very clear, because he cites from one paragraph of the Advocate General's opinion, Maduro, in Al-Ghafarji. If you read the rest, it's very clear what the Advocate General is saying. And then the court says it's supposed to track, in essence. So Article 3, jurisprudence, is very important. And under Article 3, we see that if you have home state responsibility, the case is no longer a D or an N case, the kind of case summarized by my lady when she put the question to me a moment ago. It's no longer a D or an N case, which we call pure health cases, where the risk stems from factors that cannot engage directly or indirectly the responsibility of the public authorities of the home state. That's the phrase which you have in D, it's the phrase that you have in N in the Grand Chamber. So in those cases, no one in the home state is responsible for the applicant's predicament, and their removal is prevented in very exceptional circumstances on the basis of compelling humanitarian grounds. That's the DN formulation. It's, if you like, a sui generis test under Article 3. But when you have home state responsibility, the case becomes an ordinary Suring case, where there's no reference to exceptional circumstances or compelling humanitarian grounds. And we see that, I'll take you to the cases if I may, from MSS, the Grand Chamber seminal decision on living conditions, and also a case about Somalia, Sufi and Elmi, in which there's a contest as to which test should apply. N, the UK government says N, the applicant says no, apply the ordinary Suring test, and the court applies the ordinary Suring test because the parties to the Somali conflict are responsible for the way the war was conducted, which gives rise to dire humanitarian conditions. I'm sorry, there's a lot in that, needs unpacking, and I'll show you it. But the principle is clear. These are different tests. Suring is the ordinary test. N is sui generis. It's much higher. It's based on compelling humanitarian grounds, exceptional circumstances. If you have home state responsibility, you're back in Suring. And that leads me to the fifth reason why we say that responsibility is transformative, and that is that it is very plain from the travaux that it is only D and N cases, pure health cases, that were ever intended to be excluded from 15B. The travaux say, I'm paraphrasing slightly, but I'll take you to it. The travaux say that 15B is based on, that's the word they use, the presidency uses, it's based on the jurisprudence of Article 3, but they go on to say, we don't want to cover all the jurisprudence, and what they don't want to cover is the D case. Very clear. And the reference, I can just give it to you now, if it would help. The reference is volume 4, if you want it now, volume 4, tab 48, MS 1713 at 1717.
1770 or 17?
1717, 1717.
Thank you.
Article 15B is based on, that's the word they use, I'm quoting now, based on the obligations of member states laid down in Article 3 and the jurisprudence of the ECHR, but we don't want to fully include it over the page, fully include it, hence the limiting phrase in 15B, in the country of origin, treatment in the country of origin. So those are the five reasons we say that home state responsibility is transformative, and I'll develop those submissions. But before I do so, can I just clear up some preliminaries in my learned friend's case? The first, there are 3 points, just to clear up, if I may. The first point, my learned friend correctly says at 1.4 of his case that this issue wasn't taken, the point wasn't taken before the upper tribunal. We accept that. The point was, however, taken before the Court of Appeal, and no issue was taken about the propriety of its being advanced at that point. It was obviously dealt with on the merits, and we've given you 2 cases concerning the duty on the national court to consider points of EU law, even if not advanced.
I don't read this as doing anything other than recording a fact.
My Lord's absolutely right.
Fine,
I'm sorry to take time. I'm going to move on.
Yep.
My learned friend then mischaracterises our submission at 3.3 of his case. MS 82.
Yep.
Because he says it's implicit in our case, the person who's tortured, giving rise to present mental health problems, who has an irrational fear. Well, the point is, there's no issue there in this case. It's actually a very reasonable fear because he's...
Do you accept that that is the effect of your argument or not?
Not at all.
Right.
Because he says, Mr. Hall says, he's entitled to subsidiary protection even if there's in fact no risk to be vulnerable, same or similar in the future. And then this is the problem, and the country of origin has adequate resources. We say, if the country of origin has got adequate resources, then the risk of serious harm doesn't arise because the home state can deal with them. So that's a mischaracterization of our argument.
You say that when it comes to the assessment of dealing with it, that is an objective test, not a question of what his fears are. Understand?
Yes, it's
You're saying that if they had adequate resources, he wouldn't be at risk if he went back.
Yeah, in this, absolutely, my lord. In this case, it's actually very plain, my lord, with great respect, because what the tribunal find is that if you can, the medical evidence says he's going to be at risk of suicide at three junctures. Firstly, when he's told about removal. Secondly, in the process of removal. Thirdly, when he arrives in Sri Lanka. The tribunals say, forget about the first two, we'll deal with it. The UK will deal with it. The third, Sri Lankans can't. Why can't they? They've got 25 psychiatrists in the whole of the country. The medical resources are directed in the cities, and even then they can't deal with mental health problems. Yeah. PTSD was only recognised in Sri Lanka in the aftermath of the 2004 tsunami, despite the fact that this, with great respect, has been a torturing state for many, many, many years. It's all in the evidence. This is not contested. The idea that resources in Sri Lanka are remotely sufficient is not available to my learned friend, and he doesn't make that point.
No, he's just
I want to make it clear legally.
He's just saying it's implication of your case. He's not saying that's your case. He's just saying it follows from your case. And you say, you say it doesn't. You say it doesn't. I understand.
We say it doesn't, and the reason it doesn't is because just like the UK because the UK can deal with his problems, there isn't a risk of an Article 3 breach.
Yes, I understand that.
My lords have the point.
Yeah.
I'm sorry to labour it. The other mischaracterisation is in the preceding subparagraph 3.2, where he caricatures our case, if I may say so with respect, because he says that any state responsibility for earlier acts of harm would be sufficient, and then he raises the idea of work-related stress. We say that the issue of when there is responsibility depends on the facts, because the relevant state act may be too remote. And if I can just explain what I mean by that. Even in the pure health cases, N and D, there will have been human agency somewhere in terms of how the home state allocates resources, how much resources it devotes to healthcare. Strasbourg says that effectively that's too remote to visit the home state with responsibility. So it will be a question of remoteness. Torture, our case, is perhaps as far at the opposite end of the spectrum of remoteness as you could possibly get. So that is, there's nothing in that. Having cleared those preliminary points out of the way, I wasn't going to take you to the facts.
Fine.
They're set out in our printed case.
We've had the opportunity of reading the printed cases, the judgments below, and the statement of agreed facts. So that's absolutely right. There's no need to take it.
My lord, so it's 11 o'clock and I'm going to go straight into the qualification debate. And you have that at Volume 1, Tab 2, MS 457.
Yes. Yes.
And then, if I could just show you the preamble at 5. And the point of this is to show you how important subsidiary protection is in the scheme of this directive. It's not an add-on to EU provisions on refugee status. It's an absolutely central part of this directive.
But I think we've got that, yeah.
So,
The question is whether you're within it. Yeah.
The reason I'm saying this is because the Court of Appeal tended to suggest that really the centre of gravity of this instrument was refugee status, and everything else had to be near that, if I can use a very inelegant metaphor. We say absolutely not. That's a complete misreading and misunderstanding of this instrument. If you look at Preamble 5, temporary conclusions provide rules regarding refugee status should be complemented by measures and substitutory forms of protection, offering appropriate status. Main objective is to ensure common criteria applied, minimum level of benefits is available. 9, this is important against me. 9, this is what the court took and what the Travo indicates is relevant to the exclusion of the pure health case. The third country nationals or stateless persons who are allowed to remain in the territories of the member states for reasons not due to a need for international protection, but on a discretionary basis, on compassionate or humanitarian grounds, fall outside the scope of this directive. Now, it's a puzzle because if you're an N or D case, you're allowed to stay on the territory of the host state, not on a discretionary basis, but on an obligatory basis, albeit on compassionate or humanitarian grounds. But I accept the Court of Justice say if you're D or N, you're out. So on the present state of the authority, if Embodge wasn't here, I would be arguing the broader point. I'm not. I'm arguing the narrow point, concerned about state responsibility. And then 10, the directive respects the fundamental rights and preserves the general principles recognised in particular by the Charter, etc. And then over the page, 24, minimum standards for the definition and content of substitute protection should also be laid down. Substitute protection should be complementary and additional to the refugee protection enshrined in the Convention. It's necessary to introduce criteria on the basis of which applicants for international protection are to be recognised as eligible, should be drawn from international obligations under human rights instruments and practices existing in member states. That reference to practices is something that doesn't concern us. It's actually to do with 15C. It's the victims of civil war, armed conflict provision. 26, risks to which a population of a country or a section of the population is generally exposed don't normally create it in themselves an individual threat. And the court in Embodge relied upon that, as we'll see. And then we see at 38, the UK's opted in. At Article 1, we see the purpose. The definition is set out in Article 2. The relevant definition is 2, as my Lord Tolson noted. Person eligible, substitute protection means a third country national stateless person doesn't qualify as a refugee, in respect of whom substantial grounds have been shown for believing that the person concerned, if returned, would face a real risk of suffering serious harm, as defined in Article 15. Article 17 concerns exclusion, isn't live here, and is unable or owing such risk, unwilling to avail himself of the protection of that country. And then G, application for international protection means a request that can be understood as request for refugee or substitute protection status, doesn't reference to another kind of protection which is outside the scope of this directive. And you'll see in Embodge they consider N and D cases as being applications for another type of protection. A reference to more favourable standards at Article 3, but subject to compatibility with the directive. And then Article 6 relied upon, in Embodge, actors of persecution or serious harm include state, parties or organisations controlled by the state, non-state actors. So this reverses the German and French view of actors of serious harm or persecution, which the House Laws considered in Adan. And then the all-important Article 15 is at MS 464. Serious harm consists of B, torture or inhuman or degrading treatment or punishment of an applicant in the country of origin. So that mirrors Article 3, save that you don't have the words no one shall be subject to. That omission is supplied by 2E. Do you have substantial grounds for a real risk, etc.? And then you have the additional words of an applicant in the country of origin.
Yes.
Question, what does that mean? Answer, D and N cases excluded because the treatment in D and N cases is the act of removal. In D and N cases. Home state responsibility, that's not the exclusive relevant treatment. And then just in terms of the rights that are granted, Article 23, family unity, Article 24, residence permits, Article 25, travel document, and then Articles 28, 29, social welfare, healthcare, they were relevant in Embodge.
Right. Yes.
And then this has been transposed in domestic law. I'll just give you the references, if I may, through a combination of a statutory instrument of 2006 regulations and the immigration rules. The rules are in volume 443, tab 43, MS 1673. Relevant rule is rule 339C, MS 1677. It's a faithful transposition, indeed a generous transposition, because it adds unlawful killing. Nothing turns on that.
So basically, we can take it from the...
You can take it from the Qualification Directive.
Thank you very much.
Exactly.
Indeed. Thank you.
And then the regulations which transpose
Yep.
other aspects of the directive are at volume 1, tab 11, MS 525.
Yeah. But anyway, we just rely on the directive, basically.
Indeed.
Thank you.
And then, so before, my lord, I get to Embodge, if I should make short submissions on the purpose of the directive,
Yep.
We address this in our printed case
Right.
at MS 61 to 62,
Thank you.
at paragraphs 23 to 27, where we make the point that I've already noted.
Yeah.
Innovation, new beneficiary class, the preamble at 10 I've showed you already, directive respects the fundamental rights, etc. That's an emphatic provision because it would follow on general principles of construction anyway. And see the references in paragraph 25. And then we seek to draw a parallel with the approach in the Refugee Convention in terms of the approach to interpretation. The Refugee Convention is, of course, given a generous and purposive interpretation, bearing in mind its humanitarian objects, etc., and the broad aims reflected in the preamble. You've got a similar thing here. Of course, there are limits. But 3 examples, Refugee Convention, internal flight alternative, that's not in the text, it's been implied into the text. The RTHJ cases where you wouldn't on the facts face a fear of persecution has been held to be covered by Article 182. In terms of immunity from suit, for immunity from prosecution under Article 31, as for the words entry or presence have been read to include exit. So examples of purpose of construction in the Refugee Convention, we accept that of course there are limits, but general proposition, broad construction to be applied. And then the default position, and this is important, my lords, my lady, the default position is that Article 3 informs, even if it doesn't control the interpretation of the Qualification Directive, generally, and a fortiori in the context of Article 15b. And perhaps I can just address my learned friend's position on this briefly. He says at MS 90, paragraph 6.2 onwards, that the ECHR analysis does not assist, those are his words, 6.2. And then he cites El Ghafarji. I want to just take very little bit of time before we get to Embodge on that. He cites Embodge, paragraph 19 of the Advocate General, community provisions, irrespective of provisions are concerned, are given an independent interpretation which can't therefore vary according to or be dependent on developments in the case law. Well, that's right. They can't vary according to or be dependent upon. But that's not to say that they're not highly relevant, as the Advocate General himself says. Al-Ghafarji, if I can just take you to it, is at volume 2, tab 24, MS 917. This was a case, the first of two cases the Court of Justice has considered on 15C. It doesn't, what they say about that doesn't concern us, but the comments on the relevance of the ECHR are important. And if you see, we have paragraph 19, the paragraph from which my learned friend quoted, at 923, MS 923.
Yep.
Actually, I should just show you the question that was referred, because it was a rather starkly framed question. The question is across the page, top of 922. Is Article 15C of the directive to be interpreted as offering protection only in a situation in which Article 3 of the ECHR, as interpreted in the case law of the European Court, also has a bearing, or does Article 15C in comparison with Article 3 offer supplementary or other protection? In a sense, and this is the way the Advocate General in the Court understood it, the question was inviting the Luxembourg Court to rule on what Article 3 meant. That's how they understood that question. And at 19, the passage...
Sorry, rule on Article 3, or
Sorry, what did I say?
Rule on 15C. They were being invited to take 15C beyond Article 3 of the ECHR.
But implicit in that is that they were being asked to rule what Article 3 meant.
What Article 3 meant?
Yes,
right.
Yes. And that was what was problematic. That's how it was the question was interpreted.
The question says, does it only cover Article 3 cases, or does it go beyond them?
Yes.
That's what the question says. So in order to answer that question, you would have
You've
to
got to
interpret Article 3.
And the Luxembourg Court says we can't do that. Right? This is well before Opinion 2 of 13. And all
So this
the
is,
controversy around.
paragraph 20. It's not for the community courts to determine the interpretation of Article 3. That's it, is it?
Yes.
Last sentence.
Exactly. But the important... what one then has to do is read on the following 3 pages, the following 4 paragraphs,
Yep.
because he says, nonetheless, the importance that the Convention may assume can't be overlooked. The directive pursues the objective of developing a fundamental right to asylum, which flows from general principles of community law, which themselves are the result of constitutional traditions, as reproduced in the Charter. Recital 10 is quoted, covering some of the material that we covered in our printed case, which I just showed you. And then over the page, at 22, at 924, MS 924, in that regard, the Convention is reproduced in community case law for 2 reasons. First, because the commitment which each member state has expressed to the Convention demonstrates the status of those rights as corresponding to values common to member states, which therefore necessarily wish to safeguard them and reproduce them in the context of the EU. Next, the protection of fundamental rights in the community legal order exists alongside other European systems. These include national systems and those stemming from the Convention. Each of those protection mechanisms, so that is to say EU, ECHR, national, certainly pursues objectives which are specific to it. Mechanisms are certainly constructed from legal instruments particular to them, but sometimes they apply nonetheless to the same facts. In such a context, as here we say, it's important for each existing protection system, while maintaining its independence, to seek to understand how the other systems develop these same fundamental rights in order not only to minimize the risk of conflicts, but also to begin a process of informal construction of the European area of protection of fundamental rights. 23, accordingly, although the case law of the Strasbourg Court isn't a binding source, we accept that, of interpretation of community fundamental rights, it constitutes nonetheless a starting point for determining the content and scope of those rights within the EU. Taking case law into account is more or less essential to ensure that the Union, founded on the respect for principles of human rights and fundamental freedoms, will contribute to extending the protection of those rights in the European area. In that respect, perfectly natural that the Charter, while acknowledging in 52.3 that insofar as it contains rights which correspond to the Convention, the meaning and scope of those rights shall be the same as those laid down by the said Convention. It can be noted Article 18 enshrines the right to asylum, adds that this provision shan't prevent Union law providing extensive protection. You've got all that in our footnote as well in the printed case that I showed you. For all those reasons, it's important to state that it's not a question so much of determining whether the protection provided in the directive is more or less identical to that granted on the basis of the Convention, as of defining its content in community law. perfectly sensible, if I may say so, that objective does not in the least preclude taking into account the case law resulting from the application of the convention. This is why I say, with great respect to him, my learned friend's quotation of the AG's opinion is selective. We then go on to see what the court says. So what does the court say? My lord, here, the reference is paragraph 28 at MS 934. Court at 27, at the outset it should be noted that the referring court seeks guidance on the protection guaranteed under Article 15C in comparison with Article 3. In paragraph 28, this is the all-important paragraph. In that regard, while the fundamental right guaranteed under Article 3 of the Convention forms part of general principles of community law, observance of which is ensured by the court, and while the case law of the European Court is taken into consideration in interpreting the scope of that right in community legal order, it is Article 15b of the directive which corresponds, in essence, we accept there isn't an equivalent, corresponds in essence to Article 3 of the Convention. By contrast, 15C of the directive is a provision, the content of which is different from that of Article 3 of the Convention, and the interpretation of which must therefore be carried out independently. And then this, although with due regard for fundamental rights as they are guaranteed under the Convention. What is the court saying? The court is saying that even when you've got a provision which does not correspond in essence to Article 3, you still have regard to it. The position is obviously much stronger when you've got the provision which does correspond to it. Yet my learned friend says, based on a selective quotation, as we say with respect, that the analysis of the ECHR does not assist the court. That's at 6.2 of his case. He continues, I've dealt with 6.3, he continues to say that the court in, this is 6.4, the court in Al-Ghafarji merely expressed the obiter view that 15b corresponds in essence. Well, this suggests that is wrong. Then he says the outcome in bod demonstrates decisively that the protection provided by Article 3 is not coextensive. We agree with that. There's no inconsistency there. And then he says, then he lists a number of points which, with respect, don't go anywhere. At 6.5, he says there are a number of obvious differences between two forms of protection. The qualification directive requires the country of origin to be responsible for future conduct, while Article 3 doesn't necessarily do so. Well, we respectfully submit, isn't it relevant to ask when Article 3 does hold the home state responsible?
Well, you're going to come back, I imagine, at some stage to what the treatment is in an Article 3 Serring type case.
Yes.
Okay, well, you'll go.
No, I said, perhaps I'm getting ahead of myself. I'll just make the point in relation to 6.53. He says that subsidiary protection is subject to exclusions. Article 3 is absolute. That avails me rather than my learned friend because it points to the inclusionary criteria in the qualification directive as being broader because there's a power to exclude a person. It doesn't help my learned friend, it helps me. If serious harm is subject to exclusion, but Article 3 is absolute, that suggests, on first principles, that you could construe the provision which is subject to exclusion more broadly. Anyway, you have the submissions on the relevance of the ECHR, and we say the default, it's very clear that the default provision is to interpret in the light of the ECHR case law. And then I just want to take you to the Travo, which I mentioned earlier, just very quickly at this point, and you've got that at tab volume 4, tab 48, at MS 1317, and this was the 1717. That's a relevant page. If you have that. 1716, the draft of Article 15, as it then was, is set out. The reference to unjustified harm was taken out after, I think, representations from Professor Goodwin Gill. B, you see, basically tracks what we've got now. Torture, inhuman or degrading treatment or punishment of an applicant in his or her country of origin. They remove the reference to status versus, and they put it into Article 2E. The relevant passages are then across the page at the bottom of 1717. Article 15, subparagraph B. Subparagraph B, which is generally supported by member states, is based on the obligations of member states laid down in Article 3 of the ECHR and the jurisprudence of the ECHR. That's what it's based on. And then over the page, however, if subparagraph B was to fully include the jurisprudence of the ECHR relating to Article 3, cases based purely on compassionate grounds, as was the case in D, would have to be excluded. Would have to be included. In the St. Kitts case, although the lack of access to developed healthcare as well as lack of social network in itself wasn't considered as torture, etc., the expulsion to the situation, which would have been life-threatening to the concerned person, was described as such. Consequently, to avoid the inclusion of such compassionate grounds, cases under a subsidiary protection regime, which was never the intention of the directive, the presidency suggesting to limit the scope by suggesting that real risk of torture and human degrading treatment punishment must prevail in his or her country of origin. So very clear that the drafter's intention was that only D cases should be excluded from the scope of 15B. Otherwise, not only was 15B to be informed by the Article 3 jurisprudence, it was to be based on it. Now, with that overlong run-up, may I please take you to the all-important Embodge case, and we have that at Volume 2, tab 25, at MS
938.
938. Thank you. And we address it in our printed case, just for your note, at paragraphs 30 to 40, MS 63 to 66. This decision, given in 18th of December 2014, it postdated the Court of Appeal, but predated our application for permission to this court, and we addressed it in that application. What this does, as Secretary appears to suggest, is it disposes of our broad argument that Article 15B should be interpreted to be coterminous with Article 3, but it doesn't address the narrow one, which is based on home state responsibility. The case concerned access to welfare benefits, specifically disability allowance, rather than the right of residence. This is because the applicant had been granted leave on medical grounds, but denied a disability allowance. And the issue was whether the grant of leave amounted to subsidiary protection. And if it did, then other provisions of the Qualification Directive, particular Articles 28 to 29, would be in play. The Advocate General held this wasn't enough because there wasn't home state responsibility. It was a pure health case. If you look at the head note, my lords, my lady, you just cast your eye over that, it will be immediately apparent that there was no question of Mauritania having any responsibility for what would happen to the appellant if he was returned there, just as St. Kitts wasn't responsible for what would happen to, for the absence of healthcare for AIDS sufferers, as in D. Mauritania wouldn't be responsible for the absence of healthcare for the appellant's illness, his visual impairment following an assault. The Advocate General's opinion begins at MS 940. He sets out at 7 what he's going to argue that. We need perhaps start at 1 where he identifies the question, but we can read it for ourselves. Yes. Sorry, would you like me to read it? Or?
No, we can do that. Thank you.
the point is it's a pure health case. It's an N or D type case.
Yes.
Yep. Yep.
And he says at 8, in 7 he says, I'm going to argue that you're outside scope. In this situation, the need for international protection is absent, given that the inhuman treatment arising from the individual's state of health and the lack of sufficient medical resources in the country of origin does not stem from an intentional act or omission on the part of the authorities or independent bodies of that country. Contrast our case, where our predicament precisely stems from an intentional act of historic torture and a present omission in breach of duty to provide rehabilitation. And then he sets out relevant provisions of the directive. I've taken you to them, so we can go straight to the Belgian law on page 943. And this is the law of 15th December 1980, the purpose of which was to transpose the directive, paragraph 20. And Article 9b is important because this is a provision under which leave was granted, and it says a foreign national who suffers a real risk of inhuman or degrading treatment where there is no appropriate treatment in this country of origin may apply for leave to reside. So in a sense, this isn't even N, it's sub-N, because it's applying the ordinary Suring test to N, but we can leave that aside. There's no reference in the Belgian law to compelling humanitarian circumstances. This is the approach for which the minority, the President, Judge Spielman, Judge Telkins, etc., argued for in the N case. We can leave that aside. At 22 across the page, Article 48.4 of the same law transposes relevant provisions of the directive and provides subsidiary protection shall be granted to a foreign national who doesn't qualify for refugee and to whom Article 9b isn't applicable, etc. And then it tracks Article 2e, the definition in the qualification directive. Then the law on disability allowances is set out, and you'll see that it's only to be granted to own nationals, EU nationals, Maghreb Agreement nationals, stateless or refugees. He's not one of those, and he argues essentially for non-discrimination and eligibility for disability allowance if he's got subsidiary protection, if he's entitled to subsidiary protection. And you'll see that the facts at 27, he's assaulted at a Red Cross centre for asylum seekers, left with a severe visual impairment. That's the extent of his injury. And then he, just very quickly going through the disability allowance history, he applies for loss of income allowance and income support on paragraph 30. Yeah. That's rejected. It's appealed to the Labour Court. Sorry, Noel. Yes? Oh, sorry. He appeals it to the Labour Court, which takes 31, which takes the view that he's entitled to subsidiary protection on the basis of the leave granted to him, and the social assistance provisions in the qualification directive is therefore triggered, but it refers a question to the Constitutional Court for ruling on the point that in turn the Constitutional Court was uncertain and therefore refers the question set out in 38 to the Court of Justice. Interestingly, we see that the national authorities are divided. Both the courts and the legislature think that he is entitled to subsidiary protection status, that's 35-36, whereas the executive says, no, you're not, at paragraph 37. And then the questions are referred at 38. And can I just invite you to read those, if I may? Pure health case. And then the analysis begins at paragraph 40. Again, paragraph 40, very clear that this is a pure health case. At 42, Article 15 defines 3 types of serious harm. 43, the question arises because, as El Ghafarji at 28 pointed out, as is apparent, the provision corresponds in essence to Article 3. It's apparent, and this is the principle to which I referred in opening, which my Lord Hughes very faithfully, I'm very grateful to him, wrote down, only to find that it was in the printed case. It's apparent from the case law of the Court of Human Rights that suffering which is caused by a naturally occurring physical or mental illness may constitute inhuman degrading treatment within the meaning of Article 3 if it is exacerbated or may be exacerbated by an act or treatment arising inter alia from detention conditions, removal, or other measures for which the authorities concerned may be held responsible. My Lord asked me the question, what's the treatment here? The treatment is his two candidates. Firstly, is historic torture, which remains causally relevant. Mr. Hall says that's not good enough, you need future conduct.
Yes.
Well, and he doesn't have an answer to the second candidate, which is the breach of duty, the omission to treat him, to rehabilitate him. There's a duty in international law to rehabilitate victims of torture.
Right. Well, now,
which I'll show you.
I can see the point about the breach of the duty to rehabilitate.
Yes.
But now, since you've read from paragraph 44, it might be a convenient time, if you'd rather do it later, do. I'd just like you to help us about the relationship between Article 3 of the ECHR and Article 15b of the Qualification Directive, because, as you've shown us, there is clearly a connection, or was in the drafting.
Yes.
But in a Suring-type case, what is the treatment which attracts or which falls within Article 3? Is it what will happen to him when he gets back, or is it the removal?
If I may say so, my Lord, that's a very good question.
That's something.
And the way
What's the answer?
The answer is the answer is that in the Suring case, the treatment is what happens in the foreign state.
Well, no, I don't think it is it? Think about it. The whole point about Suring is that the European Convention does not apply to the destination country. It isn't a party. The whole point about Suring is, and the route by which Article 3 prevents, in that case, the extradition of the person who would face the death penalty on return, is that this country would be in breach of Article 3 in removing him there.
Yes.
Yes?
Yes.
And is that in fact common to all the Suring-type cases?
Well, I was just going to say, if my Lord's analysis is right, and with great respect say, I can understand why you advance it, but it's not right. But if you're right, then there is never an Article 3 case that could ever come within 15b, because the treatment would always be the removal, it wouldn't be in the country of origin. So that just can't be right.
No,
The treatment has to be in the country of origin for the purposes of Article 15b.
Exactly.
And my Lord is saying the treatment in removal, in an expulsion case, is always the act of removal.
well, in a Suring case.
It could be what's going to happen in the receiving country.
Of course it could.
In the paradigm case, which is the person's going to be tortured or...
Death row phenomenon.
All the Article 15b cases where he's going to be ill-treated on return are clearly cases in which he faces serious harm on return, and therefore the removal would be a breach of Article 3. But it isn't because Sri Lanka's a party to the European Convention on Human Rights. It isn't.
No, but perhaps I can put it this way.
It's because we are.
Perhaps I can put it this way. In the Suring case, the treatment is both the act of removal and what's going to happen in the receiving state.
Is it?
Yes.
No, the treatment is the act of, may I suggest, you may be right, but the alternative view is that the treatment is the removal given that what will happen to him on return.
But what...
Anyway, there we are. That's the issue.
If it's helpful, I can go through the Strasbourg case law now. I was going to come to it later, but I can do it now. I was going to address you on Embodge. But if it's helpful, I can do
No,
it now.
do you do it in your own time, Mr. Hussain?
and-
I've raised the question.
Can we
All I
stick
need
with
to
him,
do-
Bodge?
Yeah.
Thank you.
There are plenty of Article 3 cases which are, I was going to say bog standard Article 3 cases, where it is clear that if removed to the country of origin, a person will be at serious risk of being ill-treated, tortured or ill-treated in that country.
Yes.
That's irrespective of whether that country is a party to the European Convention.
Yes.
There are loads and loads of cases like that. The problem one has with this sort of case is that it's not a risk of ill treatment now in the country of origin.
Yes.
It's the risk of not being treated as well as he should be in the country of origin.
Yes.
Arising from previous treatment in the country of origin. That's
Does
the case.
it perhaps go a little further than that, in that because of his apprehension of what will happen to him in Sri Lanka, because of the legacy of what happened to him in the past, not merely is he not going to get sufficient medical treatment, but there will be a revival of the sense of
Yes.
apprehension, to put it at its lowest.
The consultant put it in terms of he will suffer acute mental suffering. Yes.
Yes, you will.
So the return to Sri Lanka doesn't merely confront him with the lack of adequate medical treatment, it involves an exacerbation of his condition
Yes.
because of matters intrinsic to him.
My Lord, yes. I'll come back to him, Bodge, in a moment, but perhaps I can just say that what's very clear from the authorities is that you start off with Suring, that's the classic case. And I see the force of my Lord's point, because the USA is a death row phenomenon that it inflicts, is not part of the ECHR, and the Suring court says you've got to look at what's going to happen in the home country against the standards of the convention. That's the phrase it uses. But it doesn't, you're not adjudicating, you're not assuming to yourself a worldwide jurisdiction to adjudicate on death row or what's happening in Sri Lanka. But you're looking at what's going to happen in the country against the standards of the convention. That's the phrase it uses. The case law then develops in D, where the court says that it's going to extend its approach to cases where the source of the risk of the treatment in the receiving country, that's the phrase it uses, treatment in the receiving country, stems, if you want it, I'm reading from MS 1117, and this is the key paragraph 49 of D, volume 2, tab 29. The authority is at 1093. The relevant passage is at 1117. And the paragraph 49, what it says is, the court isn't prevented from looking at cases where the source of the risk, prescribed treatment at the receiving state, stems from factors that cannot engage directly or indirectly the responsibility, that's the word it uses, of the public authorities of that country, or which, taken alone, don't in themselves infringe the standards of the article. So that's the extension in D. It's that extension which is being excluded by the words in the country of origin. And the reason why they adopt that phrase is because in D, in the only treatment you've got is the removal. And we see that from paragraph 53 of D at 1119. So in the D-type case, the reason you get into Article 3 at all is because the court says the relevant treatment is the act of removal. However, in this classic Suring case, what you have, in addition to the treatment being the act of removal, is that I'm quoting from the court, the prescribed treatment in the receiving country stems from factors that do engage responsibility. So
I'm not quite clear. It's accepted that if returned, he is likely to suffer serious harm from past ill as a
yes,
consequence of his past ill treatment.
yes.
But are you saying that if returned, he will suffer treatment in the third-party state, which will cause suffering, as distinct from he will suffer from his past ill treatment? Are you saying that there will be treatment within the meaning of Article 15?
Yes.
You are. And what is
Two candidates.
what is the treatment
There are two candidates.
that he's going to receive?
The first candidate is the historic torture, and that is something from which his suffering emanates, from which it stems, and for which the Sri Lankan state is responsible. That's historic.
That's going back to the first point, past. What is the
second,
actual treatment that he's going to receive?
It's the omission to treat in breach of a duty to do so.
Well, that's the rehabilitation.
Exactly.
That I understand
Yes.
completely. But how can, if you ask the question, what treatment is he going to suffer in the future, how can that be constituted by past torture?
Because the court takes a broad approach, Strasbourg court takes a broad approach and says that Article 3 covers suffering, going back to 44 of the Advocate General, covers suffering caused by a naturally occurring illness if it's exacerbated.
Yes. For which the authorities concerned may be held responsible.
By measures.
And the authorities concerned are the removing authorities, aren't they not?
They can be, but we'll see.
We're just trying to unravel two strands.
We will see in the way the case law develops is that it's to the effect that where the home state can be regarded as responsible for measures which exacerbate suffering, then the ordinary Suring test applies. And we see that from Sufi and Elmi, the court's decision in Sufi and Elmi, that concerns Somalia, obviously outside the space juridique. And the court says there's a contest between N and Suring. And the court says that because the dire conditions are predominantly due to the conduct of the conflict, that is something for which the Somali actors are responsible. And we are therefore going to apply Suring. That suggests that for Suring to apply, it isn't just enough that removal is treatment. That was the dissentient's view in N. They were saying you should do away with the heightened N test.
But I would find it helpful if, in developing the argument, one tries, if at all possible, to keep separate two strands.
Yes.
One strand of your argument appears to be that if returned, he will suffer future ill treatment in the sense of some wrongful act or omission. Yes. This will be fresh treatment.
Yes.
And you've articulated that in the form of non-rehabilitation.
Yes.
So that will be a wrongful omission.
Yes.
Which will then bring in its wake a recurrence of suffering.
Exactly.
The second strand to your argument, and it is a conceptually different one,
yes,
is that supposing you fail on that, supposing there isn't any fresh wrongful act or omission
yes,
or risk thereof, you don't need that because European jurisprudence has developed to the point that there will be an entitlement qualification for subsidiary protection if there has been ill treatment in the past and the consequences of it will bite in the future. Yes. These are two separate arguments.
But they are.
It would be helpful, I think, to try to keep them as such. Now, you say that there's...
No, you have kept them separate.
Well, fine. But now you're going to develop the European jurisprudence in order to establish which of those two limbs?
Both.
Both.
But
Right.
if I may.
Right, sure.
The key cases, because I accept it's not clear until MSS and particularly Sufi-Nelmi, because Sufi-Nelmi is the one case where the court very clearly says N and Suring are two different tests. UK government asks for N, the applicants ask for Suring. What determines which test we apply? Answer, is their home state responsibility?
Yes.
But I'll stay with Mboj. I'm sorry I haven't helped you very much by making submissions without taking you to the cases. I'm going to do that in due course. But it's very helpful to have had a question from my Lords, Lord Hughes and Lord Toulson on the point. If I can continue in Mboj, I've lost my note. At 50... Well, just on 44, 44, where we were. So the reference to other measures for which the authorities concerned may be held responsible. The hypothetical which I'd ask you to consider is imagine that the Sri Lankan authorities were to detain my client. Now, the evidence was that if they detained, they torture. But assume that's not happening. They're just going to impose a short detention on him for a minor offence and assume that they have actual or constructive knowledge of his underlying mental state. And that detention exacerbates his condition. We say that would be a classic example of the principle in 44, the pretty principle in 52, being engaged. And the past torture, in our case, of course, doesn't just exacerbate the suffering on that strand, my lord, it causes it. The illness isn't naturally occurring, it's something for which the Sri Lankan state is responsible. And then at 50, then going back to the opinion, at 54, he summarizes D and says, in that case, essentially paraphrasing, that the removal is the treatment. The abrupt withdrawal of the treatment and conditions in the country would hasten death. 56, the court reserved to itself sufficient flexibility to address Article 3, where the inhuman treatment stems from factors, sorry, it was here, you didn't need to go to D, from factors which can't engage either directly or indirectly the responsibility of the country, or which taken alone don't in themselves infringe the standards of Article 3. In such a case, compelling humanitarian considerations. And then the question is whether similar circumstances which arise in this case fall within scope. Answer, no, they don't, at 48. And then at 51 onwards, the system by which member states may grant international protection pursues a specific aim, establishes a specific protection mechanism, which requires two key criteria to be fulfilled. First, there must be a risk of persecution or harm. Secondly, the country must be directly or indirectly responsible for there being such a risk. Now, that is in opposition to the position in D. It's D that's being excluded here. And the country is the home country, we would suggest. interest, because clearly in D, the UK as the expelling state is responsible, but St Kitts isn't. That's the extension in D, if you just cast your eye up to 46. But in 51, he's saying, no, under the Qualification Directive, one of the two key criteria are that the country must be directly or indirectly responsible for there being such a risk. And then over the page, it's essential for these two criteria to be satisfied because they form the basis of the fear and justify inability to avail oneself of protection. And then 53, Article 2E is set out. 54, the article defines serious harm in terms of acts or circumstances for which the public authorities are directly or indirectly responsible. And then 56, the last sentence is something upon which Mr. Hall understandably focuses. We say his focus is misplaced because that is not the sum of what the Advocate General is saying. Inherent in these acts, in Article 15 acts, is a deliberate intention on the part of the perpetrator to inflict particularly intense physical or mental suffering. That's got to be read alongside what is just said in 54. 44, I keep saying 50. You've got to read the last sentence of 56 in light of what he said at 44. And then, and we'll also come to MSS, you can have an omission, a breach of a duty, a culpable wrong, the effect of which is to lead to extreme suffering. You don't need the intention. And then he refers to Article 6 at 47. It's 57. And it says this defines the personal element, and the EU legislature therefore expressly limits the scope of the harm referred to in Article 8:15 to the harm caused by the state. That's not, my Lord, as my Lord Hughes put to me, it's not the UK, it's not the expelling state, it's the home state. And then 58, therefore, in order for a person to be eligible for sufficient protection, it isn't sufficient to prove the person would be at risk of being subjected to inhuman degrading treatment if he returned. It must also be demonstrated that the risk arises from factors which are attributable directly or indirectly to the public authorities of that country being the home country. That's why responsibility in the home country is so important, we submit. And he approves the French government's submission at 59 that where in the pure health case, the inhuman or degrading treatment to which he risks being subjected if returned doesn't arise from any intentional act or omission on the part of the public authorities of that state, that's the home state, or bodies acting independently of the state. In other words, one of the key criteria for eligibility would obviously not be met, that criteria being direct or indirect responsibility. Therefore, you don't need any need for international protection. And at 61, he says this essentially falls outside the scope of the directive. There was a dispute or some discussion and a dispute between my learned friend and I as to whether or not the term international protection in lines 4 and 5 is a correct translation of the French il s'agit de. You've got the French in the further supplementary bundle, which is tab 63. I'll give you the page in a minute. I needn't take you to it, just for your note. But we suggest that that's not a very good translation. It doesn't really make sense. What is another kind of protection is not international protection, because international protection if you look at paragraph 60, is what is within scope. Anyway, I don't want to take time over it. And the point, the Advocate General says that in the classic D cases, if you look at between C to D, the protection is provided in the pure health cases for other reasons on a discretionary basis. Well, that's not quite correct, but leaving that aside. On compassionate or humanitarian grounds, that is correct, based on compliance with Article 3. If protection is provided on that basis, it is the implementation of the decision by the host member state to remove the person concerned in conjunction with the lack of medical resources which may constitute inhuman treatment. So he's saying in those cases it's the removal that's the treatment. That is indeed what was said in D. But however, the EU legislature clearly wished to exclude such cases, and then recital 9 is prayed in aid, which I've already taken to you two, and 64 is the travaux, again, which I've already taken you to. That misses out the first bit of the quotation where they say that Article 15b is based on the Article 3 jurisprudence. So that is 1718 in your electronic bundle. It's the previous passage at the bottom of 1717, which is also important. And then he says at 65, although the court in El Ghafaji said that Article 15b corresponds in essence, the EU legislature limited its scope to the treatment of an applicant in the country of origin, which presupposes that the public authorities of that country are directly or indirectly responsible. And in that regard, it's a distinct scheme. Then he makes certain observations about a more favourable standard with which we needn't concern ourselves. The court begins its judgment at the bottom of 952. I can go straight to the analysis, which is at 28, paragraph 28, at the top of 958. At 30, the court records that there are 3 types of harm in Article 15. And at 31, they say the risks faced by a third country national of a deterioration in his state of health, which isn't the result of that person being intentionally deprived of health care. So they regard that as an exception to the exclusion, against which the nationalisation at issue in the main proceedings provides protection. So again, it's very clear that they're just dealing with the pure ND case, are not covered by A or C. Next paragraph, Article 15b is set out. 33, it's clear from that provision that it's applicable only to inhuman treatment of an applicant in his country of origin.
Now, their definition, their description of 15b
Yes.
isn't quite the same as the Advocate General's, is it? Because I was interested.
Yes.
Paragraph 54,
Yes.
the Advocate General on MS
Yes.
949 had said that the article defines serious harm in terms of acts or circumstances for which the public authorities in the country of origin are directly or indirectly responsible. And I couldn't see where actually that, I mean, that's interpretation, but I couldn't see it was defined in 15 in that way.
No, I think defined is too strong.
It's not the right word.
No.
And it raises questions, what do you mean by directly or indirectly responsible? But the court doesn't adopt that. The court states its effect rather differently, doesn't it?
Well, we would say that actually the exception, I accept it doesn't use language of responsibility, I accept that. But we would say that the exception to its exclusion, in other words, the intentional healthcare deprivation case is precisely an example of the responsibility notion which runs through the Advocate General.
And one thing is clear, which is they simply didn't have this type of case in mind.
Right.
Yes,
That's the trouble.
that's obvious. This is all about the pure health case. And of course, one knows that the strictures of unanimity can yield.
How much can we get from this? Because of the very point that Lord Toulson's made, and you've accepted, that they weren't concerned with this sort of case.
Well, what you get from this is what the court regards as important in terms of the 15B criteria.
In the context of those facts, yes.
In the context of those facts. But in a sense, I'm able to say that even in that context, which is very far removed from mine, if you look at what they're interested in, I get home. And I'll make that good in a moment, if I may, because at 33, the court says that the treatment's got to occur in the country of origin. At 34, they say that certain factors specific to the context must be taken into account. And the key paragraphs are 35 to 37, for reasons which will become apparent in a moment. At 35, they say Article 6 sets out a list of those deemed responsible. So it does refer to responsibility there for inflicting serious harm, which supports the view that the harm must take the form of conduct on the part of the third party, or of a third party, and therefore, and that it can't therefore simply be the result of general shortcomings in the health system. Well, we are not a case of
That's not an issue, no.
No. At 36, and there is conduct on our case, there is conduct.
You understand?
36, recital 26 states that the risks to which the population of the country, the section of the population that is generally exposed, don't normally in themselves create a threat. Well, this is not a population-wide phenomenon, even in Sri Lanka, torture and failure to rehabilitate. It follows that the risk of deterioration in the health of a third country national suffering from serious illness in the absence of appropriate treatment isn't sufficient unless that third country national is intentionally deprived of health care to warrant that person being granted subsidiary protection. And then 37, the interpretation is supported by a number of recitals which essentially come down to the scope of the provision doesn't extend to persons granted leave on a discretionary basis on humanitarian or compassionate or humanitarian grounds. Those are the key concerns, and that's apparent from paragraph 44 across the page, because those are the concerns which the courts say effectively inform. So it seems it's saying that's what informs what it considers to be the rationale of international protection. We see that from 44. So you've got, the three factors seem to be, if you've got conduct, is this something that's generally occurring? And is it something, is the leave granted on compassionate or humanitarian grounds? None of those factors are in play in our case, we respectfully submit. The court goes on to deal with the Article 3 question at 38 onwards, and it says the requirement to interpret Article 15b in a manner consistent with Article 19.2 of the Charter, that's the non-refoulement provision in Article 3, that's Sirring, if you like, to the effect that no one may be returned to a state, etc., is not such as to call that interpretation into question. So in other words, what it's saying is, look, that general principle doesn't go as far as saying that a D or N type case is covered, and it refers to the N decision at 39, referring to the fact that in that such a case, the humanitarian grounds against removal are compelling. That's the test. See at the bottom of 39. And at 40, that doesn't mean that somebody should be granted subsidiary protection. So there isn't an equivalence, but plainly Article 3 is very relevant. And then the conclusion at 41. So what we get from this is that if you look at the criteria the court says are not met in the D case, type case, that is illuminating because we say we meet those criteria at 35, 36, 37. And then if you look at the exception to exclusion which the court carves out, the intentional deprivation of healthcare, that is a reflection of the pretty principle, of the exacerbation principle, because it's very clear that the intentional deprivation of healthcare won't, in many cases, be coterminous with the serious harm itself. It will cause it. It will lead to it. And then, my lords, I was going to move off Mbodge and then go to to the question of Sri Lankan responsibility, just to tell you where we deal with it in our printed case, and just to take you to some materials on rehabilitation. So we deal with it at paragraphs 42 to 44, MS 66 to 67.
Yep.
And the other strand, the duty to rehabilitate, at 45 to 46, MS 67. If I can just take you to Professor Nowak's work, which we cite at 45, you have that in, I'm afraid it's a further supplementary bundle. It was in our original authorities, but not fully copied. And you've got it in the further bundle at tab 61. I hope you've got those. It should be a black folder on your desks, and
yes.
You also ought to have memory sticks.
Yes,
as well.
Thank you.
And the MS reference is 2236.
Yep.
And you'll see there at 2237 over the page. I'm sorry that you can't see the pagination.
Yes, don't worry. Which internal page number?
It's a title page.
Yeah, okay, fine. Yep, we see that.
Page.
Yep.
Article 14.
Yep.
Each party shall ensure in its legal system that the victim of an act of torture which obtains redress has an enforceable right to fair and adequate compensation, including the means for as full rehabilitation as possible. And over the page, internal 481, it was made clear that rehabilitation, at the bottom of paragraph 72, middle of the page, it was made clear that rehabilitation encompasses various measures, including social and medical assistance. This broad understanding reflected in the practice of the committee. In the Argentinian case, the committee observed the democratic government of Argentina is morally bound to provide a remedy to victims of torture to dependents, notwithstanding the fact that acts of torture occurred before the entry into force of the convention. 74 at the bottom of the page, the leading case is Guridi v. Spain. The victim had been tortured by 3 members of the Spanish Civil Guard. Although a criminal court had found all 3 of them guilty, sentenced them to imprisonment and to pay compensation, they were later pardoned by the king. The committee found a violation of Article 14, in spite of the fact that the guards had paid the compensation to the victim, justified this holding by considering that compensation should cover all the damages suffered by the victim, which includes, amongst other measures, restitution, compensation, and rehabilitation. And then the committee didn't make an explicit reference to the basic UN guidelines, but the terminology corresponds to those that broadly to that developed in the guidelines. 676, Article 14.1 is a specific manifestation of the general rights of victims of human rights violations to remedy. 77, at the substantive level, the right to remedy means fair and adequate reparation for the pain and humiliation suffered. Over the page, internal 483, usually victims of torture aren't primarily interested in monetary compensation, but in other means of reparation which are better suited to restore their dignity and humanity. 78, the Van Boven-Bassioni guidelines, those are the UN guidelines, mentioned above, provide for different categories of reparation. Since victims of torture often suffer from long-term physical injuries and post-traumatic stress disorders, various types of medical, psychological, social, and legal rehabilitation are usually best suited to provide relief. Long-term rehabilitation measures, which are often provided by special torture rehabilitation centres, are fairly cost-intensive. Respective costs should ideally be borne by the individual perpetrators, their superiors, and the authorities directly responsible. States provided effective remedies ensuring that the individual perpetrators are held accountable to pay all the costs of long-term rehabilitation. This would probably have a stronger deterrent effect than criminal punishment. And my lords, my lady, will be very well aware that the duty to not only to prohibit torture but to prevent it is a central animating theme in this convention. We were interested to know the reference at 113 to various Sri Lankan cases. We've tracked all of them down. You don't have any of them. You don't need any of them. They all none of them concerns Tamil torture victims. But what happens in all of them is that the Sri Lankan court orders both the perpetrator and the state to pay compensation. But they don't concern LTTE, separatist Tamils at all, out of interest. We have the cases if you want them. We don't want to burden you. The Van Boven guidelines, I won't take you to them, I'll just give you the reference if I may. They're in volume 4. My note says tab 4, which is good. But the MS number is 1704. It's 47, tab 447, 1704. The relevant paragraphs are paragraphs 15 and 21 at MS 1710 to 11. 15, reparation should be proportional to the gravity of the violations and the harm suffered. And 21, rehabilitation should include medical and psychological care as well as legal and social service provision. And as I've said too many times, this is an aspect of our case which simply isn't traversed by a learned friend.
So the absence of rehabilitation
Yes.
is the degrading treatment for the purpose of 15B.
No. It's the act for which the Sri Lankan state is responsible, which leads to, which exacerbates treatment which falls within Article 3. The act need not itself be the Article 3 ill treatment. That the failure of the duty, if it causes suffering of sufficient intensity so as to amount to Article 3, so as to be covered by Article 3, it is treatment. It needn't itself be coterminous with the Article 3 or treatment. So I put that very, very badly. But you've got the idea. I can't do better than the quotation from Pretty, which you have in the Advocate General in Budget 44, in our printed case at 38. Yep. It's what I started out with. The suffering which flows from naturally occurring illness may be covered by Article 3, where it is, but the suffering risks being exacerbated by treatment So it's not the inhuman treatment itself. You've got treatment somewhere else, earlier in the causal chain, and the treatment can flow either from conditions of detention, expulsion, or other measures for which the authorities can be held responsible. I'm sorry I put it so badly.
Let us suppose that the rehabilitation available in Sri Lanka was objectively suitable to treat someone such as the appellant.
Yes.
But because of his predisposition
Yes.
to suicide,
Yes.
by reason of the treatment that he'd received historically,
Yes.
he is incapable of availing of the treatment in Sri Lanka to bring about an amelioration of his condition.
Yes.
Is he entitled to succeed?
Yes, he is.
On what basis?
Because, well, on two bases, on both strands. Because the rehabilitative treatment that is provided in Sri Lanka isn't effective in that case.
Well, I'm asking you to proceed on the premise that it's objectively of a standard,
Yes, but
which would be acceptable, but because of the peculiar condition of the appellant,
Yes.
he's unable to avail of it.
well, we would say that that is something which is also objective. The condition of the appellant is something that can be objectively testified to by medical evidence. And the medical evidence says, look, the torture was so bad that he can't go anywhere near his past torturers. Then we would say that whatever the position in theory,
But it isn't a failure on the part of the Sri Lankan authorities to provide adequate treatment. It's because of the appellant's personal condition
yes,
that he can't avail of treatment which the Sri Lankan authorities have provided. So there's no question of them being found to be deficient in the treatment that they supply. It's simply a matter of circumstance that he personally cannot take advantage of it. So there's no active failure on the part of the Sri Lankan authorities.
Well, I suppose this raises the sort of deeper question about how you approach questions of protection generally, and whether it's acceptable to approach such questions at almost a theoretical level, at a systemic level.
The hypothesis put to you by Lord Coe is not far from the findings of fact by the upper tribunal. If we look at MS page 225, they examine the medical evidence, and at paragraph 444 they refer to Dr. Skogstad's report, and the really pertinent bit, I think, is the subparagraph 525,
Yes.
where the professor or the doctor had said at line 3, even if there were adequate mental health services in Sri Lanka, his suspicion of the professionals in his own country would be too great to trust them sufficiently to accept any treatment. It would therefore be impossible, in my view, for him to seek out treatment by himself in Sri Lanka.
Yes.
They accepted that,
Yes.
and that formed part of the basis for the finding that was an Article 3 risk.
My Lord, with respect, has misread the upper tribunal's decision, because the basis on which they concluded that he could not be returned pursuant to Article 3 was not on that basis, but on the basis that there were not adequate mental health services. Objectively.
Right.
So my Lord's question actually doesn't arise. I understood my Lord's question as a hypothetical.
Yeah,
It
it is very much hypothetical.
It doesn't for a moment arise on these facts, and you'll see. I'll show you why it doesn't.
Okay.
If you look at 40 over the page 454,
4.5.
the evidence is that there are only 25 working psychiatrists in the whole of Sri Lanka.
Right.
Well, there's some mental health facilities. The guidance note records an observation that money spent on mental health only really goes to large mental health institutions in cities, which are inaccessible and don't provide appropriate care for mentally ill people. And then if you look at the bottom of the page, 456, we approach assessment of his circumstances on the basis to be possible for the respondent to return the appellant to Sri Lanka without his coming to harm, but once there, he'd be in the hands of Sri Lankan Mental Health Services. The resources are sparse, limited to cities, in light of the respondent's own evidence that their facilities only in the cities, and they don't provide appropriate care, and the severity, etc. So it's, with respect, miles away from the hypothetical.
Yes, but what I'm trying to get at is, if one removes from the equation the question of the adequacy of the medical health services, and I do appreciate that this is very far removed from the present case, is there still sufficient in the appellant's case to allow him to succeed on the basis that because his return to Sri Lanka, in light of the history that he has suffered, will animate or revive or exacerbate his mental condition, that's enough to get him home?
Well, I was trying to... Well, I've got two horses that I want to ride.
Yeah.
And I want to say that I can ride both of them, even in response to my Lord's hypothetical, which, as I hope I've demonstrated, does not arise on these.
No, quite.
But the way I would say that on the rehabilitation point, I can still advance my argument is to say that that generally speaking, the protection that is provided by a state in respect of harm emanating not from that state itself, here an earlier version of it, has got to be effective to eliminate the suffering. And if it's not, then it's not enough, even if measured objectively in a systemic or theoretical way, it would be. And that raises a deep question about what theory one applies in the context of protection from non-state agents of harm, rogue state agents, and so forth. And whilst in non-state agent context, the prevailing law in here, although not followed internationally, is that systemic protection is enough. That's Horvath. But where you've got the harm emanating not from skinheads in Slovakia, but from emanations of the state itself, rogue actors, or here past actors, then the duty is a very high one. There's case law on this, which we don't have because the point doesn't arise on the facts, but we can, I can try to get it if you'd like. There's a decision of Lord Justice Sedley's which interprets Horvath to this, in this effect. Do you remember this one?
Well, I don't think you need to be distracted by that.
That's one. My one answer. That the duty is to provide effective protection, effectiveness measured in the individual case.
Yeah. Well,
The second answer.
If that's a medical impossibility, I don't think that takes us very much further. But leave that aside. It's really the second option that I want to concentrate on.
Well, the second option, we would say that again, the historic treatment, the historic torture, which remains causally relevant in his state, is sufficient treatment. Can I take you to the ECHR authorities, please? Because I think...
Yes.
Just before you do that,
Yes.
may not your case be stronger if he has an inability, because of what he suffered, to access whatever medical services there may be, than simply if there aren't medical services in Sri Lanka at all? Because if, as you say, well, actually the basis of this decision was there just aren't these services in Sri Lanka, you then run into the point, well, if they're not being deliberately withheld, that's tough, but it doesn't entitle him to subsidiary protection. Whereas, if he's unable to access medical assistance because of the ill treatment that he's received, you're in a position to argue that's not just a reflection of the general state of health in Sri Lanka, that is specific to his position.
My Lord's absolutely right, but right on what I say with great respect is a false premise. The false premise. And the false premise is that the approach in Mbodj, the exception which they carve out in Mbodj, applies here. The exception in Mbodj is the intentional deprivation of healthcare in circumstances where there is no duty to provide healthcare. This is completely different because there's an international duty to rehabilitate. A negligent omission is enough. Any omission is enough. You've got to do it. Whether or not you intend to do it, whether it's malignly motivated, whether that your motivation is benign, doesn't matter. The duty's there, you don't act, you're culpable, you're responsible, there is conduct. And therefore, we respectfully submit that my Lord's absolutely right. If I was hamstrung by that test, then I could rely on that, but the premise of my Lord's question with respect is wrong. So I was going to take you, my lords, my lady, to the healthcare authorities. Can I dive straight into N? Because we've effectively looked at D already, and we'll see the heightened test in N that is applied, and moreover, why it is applied. You have N at volume 3, tab 32. And I can go straight to the principles which the court sets out, and you have them at page 1210. In summary, the court observes, since D, it's consistently applied the following principles. Aliens who are subject to expulsion can't in principle claim any entitlement to remain in the territory of a contracting state in order to continue to benefit from medical benefits and so on. The fact that the applicant's circumstances, including life expectancy, would be significantly reduced if he were to be removed from the state isn't sufficient in itself to give rise to a breach of Article 3. The decision to remove an alien who's suffering from serious mental or physical illness to a country with facilities for the treatment of that illness are inferior may raise an issue, but only in a very exceptional case where the humanitarian grounds against the removal are compelling. And in the following paragraph, the court considers, line 2, that it should maintain the high threshold in D, which it regards as correct in principle. And then the following word is very important. Given, so this is the reason, that in such cases the alleged future harm would emanate not from the intentional acts or omissions of public authorities or non-state bodies in the home state, my lord, but instead from a naturally occurring illness and the lack of sufficient resources to deal with it in the receiving country.
Yep.
And then we can go to MSS, if I may.
Yes.
MSS, so you, certain of my lords may recall this from the EM Eritrea, the Dublin case of EM Eritrea. This is...
It's the next tab, yep.
Next tab, and this is a seminal case. It's the first case to hold that street homelessness may violate Article 3. The route it took to that conclusion is very interesting for our purposes. As I said, it's a Dublin case concerning an Afghan asylum seeker who claimed asylum in Belgium, having travelled via Greece. The judgment begins at 1264. The court first looks... The court considered both Belgian and Greek liability. Greece first. First, it considers Greek liability for detention conditions. That's not interesting for us.
Right.
It then looks at Greek liability for living conditions, which is very interesting for us.
Paragraph
1292.
Thank you.
Paragraph 7. Paragraph.
Yep.
249.
Wait a minute. 1292.
Sorry? 1272. Did I say no?
You said, yep. 1272. Thank you.
It's 1272.
Yeah, I got it, yeah.
Paragraph 249 merits. This is living conditions in Greece. The court has already reiterated general principles. It considers it's necessary to point out that Article 3 can't be interpreted as obliging the high contract parties to provide everyone within their jurisdiction with a home. Nor does Article 3 entail any general obligations to give refugees financial assistance to enable them to maintain a certain standard of living. The court is of the opinion, however, that what is at issue in an instant case can't be considered in those terms. Unlike in the previous case, the obligation to provide accommodation, etc., has now entered into positive law. Greek authorities are bound to comply with their own legislation, which transposes community law. This is the reception directive. You'll see this is redolent of my rehabilitation argument here. Failure to act in circumstances where you've got a duty to do so. What the applicant holds against the Greek authorities in this case is that because of their deliberate actions or omissions, it has been impossible in practice for him to avail himself of these rights and provide for his essential needs. 252, the court's got to determine whether such a situation of extreme material poverty can raise an issue. And then over the page, the critical paragraph at 263, MS 1294, in light of the above, in view of the obligations under the reception directive, the court considers that the Greek authorities haven't had due regard to the applicant's vulnerability as an asylum seeker and must be held responsible because of their inaction for the situation in which he's found himself for several months, living in the street with no resources, etc. The court considers that the applicant has been the victim of humiliating treatment, showing lack of respect for his dignity, etc. It considers that such living conditions, combined with prolonged uncertainty in which he's remained, and the total lack of any prospects of situation improving, have attained the level of severity required to fall within scope. And then it follows that through the fault, so it's a fault-based approach, not an intentionality or motivation-based approach. It follows that through the fault of the authorities, the applicant has found himself in a situation incompatible with Article 3. In response to my Lord Kerr's question, would the Sri Lankan authorities be at fault here? Answer, yes. Would they be at fault even if they were providing at a theoretical level rehabilitation facilities? I would say yes. But in a sense, I don't need to go that far. I can rest my case on saying, on the tribunal's findings of fact, which were, I mean, it would have almost been irrational to say anything other than they did. On the tribunal's findings of fact, Sri Lanka is at fault. It cannot provide for rehabilitation. And you see the responsibility, the importance of responsibility in the paragraph 263 as well. And in the expulsion context, they deal with this aspect of the case as against Belgium at paragraphs, at 1292, at paragraphs 362 to 368. And it essentially says, the court says, the Grand Chamber, this is 366, in this case, the court has already found the applicant's conditions of detention, living conditions, degrading. These facts were well known. It can't be held against the applicant. He didn't inform Belgian authorities, etc. And then 367, based on these conclusions and the obligations incumbent upon Article 3, in terms of expulsion, the court considers that by transferring the applicant to Greece, the Belgian authorities knowingly exposed him to conditions of detention, living conditions that amounted to degrading treatment. Now, what's important here is that there is no suggestion of an end test being applied as regards the expelling state. And this, I hope this goes some way to answering my Lord Hughes' question earlier. So what you've got is, in Greece itself, Greece is at fault. Yeah. And that is something for which it's responsible. That responsibility, the fault, leads to suffering, which qualifies under Article 3. When it comes to Belgium, the court doesn't say, look, there's no right to a home in the convention, just as there's no right to health. And no one's responsible in Greece. We're going to apply N. They don't do that. They say they apply the ordinary approach. And that is very evident in the following case, the Sufi and Elmi case,
Yep.
Volume 334, 1325 MS, which concerned the expulsion of 2 Somali nationals. A breach of Article 3 was found. The case is interesting in its approach when considering conditions in the refugee and IDP camps. The judgment is at 1368.
Thank you.
And we see that at 278,
Right.
which is at 1385,
Yep. They cite MS in Belgium at 279, yep, and N at 278.
Exactly.
Yep.
So that's the contest. N at 278, MS at 279,
Yep.
and over the page at 280, the present case, the government submitted. And just for your note, while I'm doing this, we deal with this in our printed case at paragraphs 56 through to 60 at pages 70 to 71. Thank you. And at 280, the court notes that the UK government submitted, albeit prior to MSS publication, that the N test was governing. Humanitarian conditions would therefore only reach the Article 3 threshold in very exceptional cases where the grounds against removal were compelling. The court recalls an N concerned the removal of HIV-positive applicant to Uganda. In reaching its conclusion, the court noted that the alleged future harm would emanate not from the intentional acts or omission from public authorities, but from a naturally occurring illness and the lack of sufficient resources to deal with it in the receiving country. The court therefore relied on the fact that neither the applicant's illness nor the inferior medical facilities were caused by any act or omission of the receiving state. That's the critical thing in the pure ND case. If the dire humanitarian conditions, 282, in Somalia were solely or even predominantly attributable to poverty or to the state's lack of resources to deal with a naturally occurring phenomenon, such as drought, the test in N may well have been considered to be the appropriate one. However, it's clear that while drought has contributed to the humanitarian crisis, that crisis is predominantly due to the direct and indirect actions of the parties to the conflict. The reports indicate that all the parties to the conflict have employed indiscriminate methods of warfare in densely populated urban areas with no regard to the safety of the civilian population. This fact alone has resulted in widespread displacement and the breakdown of social, political, and economic infrastructures. Moreover, the situation has been greatly exacerbated by al-Shabaab's refusal to permit international aid agencies to operate in the areas under its control, despite the fact that between 1/3 and 1/2 of all Somalis are living in a situation of serious deprivation. Consequently, the court doesn't consider the approach adopted in N to be appropriate in the circumstances present in the case. Rather, it prefers the approach adopted in MSS v. Belgium, which requires it to have regard to an applicant's ability to cater for his most basic needs. That's essentially the Suring test, stripped of any exceptionality, compelling humanitarian gloss. So we say that Sufinelmi and MSS enable us to say that where the home state is responsible or predominantly responsible for the individual's predicament, then the ordinary MSS or Suring test applies. Why is that important? It's important because it takes you out of the N or D sui generis paradigm into the orthodox Article 3 paradigm. And if you look at the travaux, you will see that 15b is based on the Article 3 jurisprudence apart from D. And I should say that in Sufinelmi, the acts, although it's not completely clear, the relevant acts, the best way to do it, I won't take you to the passages, but we say that they are historical acts, that the conduct of the war historically was such as to give rise to present-day problems. The if you go back to 1386, 282, 101, 102, you'll see the references that the court gives to passages in its facts. I don't want to trawl through those, but if you can trace them, and the conduct was historical. The court is saying, you behaved in an appalling way. You, the parties, behaved in an appalling way. That is what has predominantly given rise to the appalling conditions. If someone is going back to those conditions, they can say, this is not a case of no human agency, home state authorities not being responsible for my predicament. No, they are responsible. Therefore, that person is entitled to claim the ordinary Suring MSS approach rather than the heightened exceptionality, compelling humanitarian N approach. That's all I was going to say about the Strasbourg cases. There is one domestic case which is very important and supports us. It's a decision of Lord Justice Sedley. My learned junior, Mr. Mackenzie, appeared for the appellant. It's the case of Y, and you have it in Volume 1, tab 16, at MS 655. And you'll see that the facts are redolent of the position here. We deal with this in our printed case at MS, I think it's 74, yes, MS 74 to 75, paragraph 72 to 74. We say this is redolent of our case. It was relied upon by the tribunal in allowing my client's appeal. You will see from the head note that the appellants have been tortured by the Sri Lankan security forces. Both had been raped, both suffered PTSD, and the appellate procedures before the Court of Appeal concluded that removal to Sri Lanka wouldn't violate convention rights, in particular by causing them to take their own lives. And the head note omits what is the most important aspect of the case, certainly for our purposes.
Yeah.
Because
Where do we look at that for that?
you get that at 49 to 50, MS 667 to 668, and we cite it at paragraph 74 of our printed case, MS 75. So at paragraph 49 of the judgment, Lord Justice Sedley sets out N, and this is a 2009 decision, so it predates MSS, it predates Sufi and Elmi, but Lord Justice Sedley, if I may say so with great respect, is ahead of the curve.
It's really paragraph 50 you're allowed. Is that
Yes,
right?
that's what I said. Yes.
The distinction, the first distinction. Yeah. Yep.
Yes, exactly.
It's the compelling gloss point.
Yes.
Yes,
Yep.
you don't need it.
Exactly.
Exactly. Thank you. Then, my Lord, the final substantive point we make, and I'm ahead of time, the understanding that I certainly had is that I had a global period of 2 hours 45. If I finish before 1 o'clock, I wish to carry over.
Well,
the
yes,
time.
I mean, I have to say that we did rather take the view that this was quite a generous time estimate for both of you. But
I'm sorry.
well, no, I said we did take the view that it was rather a generous time.
I'm apologising for.
No, I'm not asking for an apology. I'm just making that observation as you were telling us about the time. Yes, carry on, don't worry.
In fairness to my learned friend, he's indicated that he doesn't think he's going to be as 1 hour 45. In our printed case, we suggest reasons why you should narrowly construe the exclusion from Article 5b. That's at paragraph 75 to 78, MS 75 to 77. I can just give you references there, rather than taking you to any of the authorities. First of all, we have the broad purposes, the general purpose of the Qualification Directive at 75 of our printed case. This is MS 75. Then we note there was a powerful dissent from the former President Spielman, Judges Tolkins and Bonello in N itself. There's an Inter-American Commission case which doesn't follow D or N, and the reference there, if you're interested, volume 4, tab 40, MS 1615, and the relevant page where the key paragraphs are set out is MS 1632. You have paragraphs 90, 91 and 94. Mwangi in Belgium is 336 MS 1480. Mr. Justice Blake at GS is at 117. And should have the MS 672. And SJ in Belgium is at 339, 1599, notable for the Portuguese Judge Pinto de Albuquerque's dissent. And we note that N is presently subject of consideration by the Grand Chamber. There's a mistake there, it's Paposhvili, not Poposhvili. Paposhvili. Then, my lords, to conclude, I opened by saying that responsibility is transformative. But torture is a paradigm transformative case. We see that when we look at what torture has done to the ECHR. The Article 3 non-refoulement rule, established in Suring, was derived from Article 3 of CAT. The Article 3 investigative duty was derived from Article 12 of CAT in the Aydin case. And you've got that in the further supplementary authorities, tab 58, MS 1998, at paragraph 103, MS 2047, that the court located the investigative duty in relation to Article 3 in Article 13, in that case, basing itself upon Article 12 of CAT. That was then moved into Article 3 itself in the subsequent decision in Asanov. That's further supplementary authorities 59 at MS 2082, paragraphs 101 to 102, MS 2130 to 1. Torture is what gave rise to the first ever flagrant Article 6 violation case, that's Oppmann. And we submit that it would be unacceptable if a victim of torture suffering extreme mental illness could not hold his home state responsible for that torture and for its failure to rehabilitate him in relation to the suffering that he subsequently endures. We say once responsibility is established, then Article 15b is met, and we say neither the EU legislature nor the Court of Justice would conceivably hold otherwise. This case is very considerable distance away from Mbodj. If we're wrong about all of that, then we say it's appropriate for a reference. Lords, my lady, those are my submissions.
Thank you very much indeed. Thank you, Mr. Hussain. Mr. Mackenzie. Mr. Hall.
My Lords, we adopt our written submissions. Paragraph 3.3 of our case was mentioned at the beginning of Mr. Hussain's submissions. Do you remember the example we gave? We were getting at the point that was made by Lord Kerr in earlier argument, which is on the appellant's case, he would be entitled to subsidiary protection even if resources were available, but if subjectively he was unwilling to avail himself of them. So that was the point we were getting at.
Because of the word unwilling.
Exactly, yes. Exactly. My Lords, there are two aspects which I'd like to draw attention to in oral submissions, which I think will be brief. We say that two aspects must both be present in order to qualify for protection under the directive. Firstly, there must be serious harm that has been inflicted by actors, And we submit that when you look at the terms of the directive, it is talking about a different sort of harm, contrasting infliction by actors with the broader subjected to harm that one gets from the words of Article 3. Secondly, we say that serious harm under the directive must be inflicted in the future on return to the country of origin. So it is insufficient if it was inflicted in the past. Before I do that, can I make one short observation on the findings of the tribunal? As your lordships are aware, the finding was a conventional Article 3 finding based upon an objective lack of healthcare available within Sri Lanka. The tribunal applied the case of J. Let me give you the reference, I won't take you to it. It's paragraphs 450 to 51 at MS 226. J, again I'll give you the references, is the decision of the Court of Appeal presided over by Lord Justice Dyson, in which it was accepted by the court that the principles in D could apply to a suicide case. In fact, J was another Sri Lankan case where the risk of suicide arose from his previous torture. And you'll get that from the judgment in J at paragraph 6, where the facts are recited. And a reference to J is at MS 607.
Thank you.
After I've dealt with the two fundamental aspects, I'm going to deal briefly with the arguments that Learned Friend makes based upon the phrase a naturally occurring illness. You recall he says this is not a naturally occurring illness, therefore different considerations apply, and his arguments upon state responsibility. In our submission, neither of those considerations are capable of bearing the weight that he seeks to put upon them. So turning then to the question of infliction of harm by actors under the directive. Inflicted is not in fact a word that's found anywhere in the directive, but it is a word that was used both by the Advocate General and the court in the Umboj case in order to elucidate the sort of harm that is required under the directive and to distinguish it from the sorts of harms that do not qualify under the directive. Now, the reason that they did this is because both the Advocate General and the court accepted that Article 15, which defines serious harm, had to be read together with Article 6. Can I just take you briefly to the directive, MS 461?
Yes, please. So what are we looking at on
Article 6.
Article 6, right?
So Article 6 is the provision that shows that actors of persecution or serious harm being relevant here, include, and then it lists out the state, parties controlling the state, or non-state actors where there is inability or unwillingness to provide protection. Now, if I can take you to the Umboj case, what the Advocate General does at paragraph 49, which you'll find on, forgive me, 49 on MS 948.
Right. Thank you. Yep.
He picks up the word infliction initially at 49. Having said at 48, I do not think the person suffering from a serious illness may fall within the scope of that directive on that basis. Although in certain circumstances the suffering caused by an illness might constitute inhuman or degrading treatment, the fact remains that one of the key criteria for eligibility for subsidiary protection, namely the identification of those responsible for inflicting harm against whom protection is needed, is not fulfilled. And one can see the basis for that by turning to 54, 55 and 56 on page 949.
Yep.
So having said that the Article 2E defines serious harm in terms of acts or circumstances which the public authorities of the country of origin are directly or indirectly responsible, Article 15, he continues, must be read in conjunction with Article 6 thereof. In Article 15 of the directive, the legislature defines a substantive element of serious harm. It consists of the death penalty, etc., etc., etc. And then picking up the final sentence, inherent in those acts is the deliberate intention on the part of the perpetrator to inflict particularly intense physical or mental suffering. In Article 6 of directive, on the other hand, the legislature defines the person element since it defines the actors of serious harm. And then this, the EU legislature therefore expressly limits the scope of the harm referred to in Article 15 of that directive to the harm caused by the state, by parties, organisations controlling the state, if it can be demonstrated, etc., etc. So, and then at 59, I'll come back to 58 later on in my submission, but 59, you'll recall the court accepts the French government's observations, and it's really the final sentence of that paragraph. In other words, in such a case, one of the key criteria for eligibility for subsidiary protection laid down in Article 6 of the directive, namely the public authorities in the country of origin should be directly or indirectly responsible for inflicting the serious harm against which protection is needed, would obviously not be met. So that's what the Advocate General did. He read 6 together with 15 and drew out this concept of infliction of harm. Now, the court is slightly less emphatic and clear, but the reasoning we would submit is identical.
Well, he talks about both causing and inflicting, doesn't he?
But deliberately, yes.
Mr. Hussain says that they have inflicted it.
Yeah.
He says they've caused it.
Yeah.
Certainly, that they caused it.
Yeah.
Well, that brings us back to the point, yeah, exactly.
It's not a naturally occurring thing.
Well, I'll come on to the naturally occurring thing in a moment, if I may. So just sticking with this point that the harm that we're dealing with has to be inflicted and deliberately inflicted or caused, the court in its judgment accepts this analysis at paragraphs 32 to 35.
Yes.
So having referred to Article 15b defining serious harm, referred at 33 to the fact that it's applicable only to the inhuman or degrading treatment of the applicant in his country of origin, then says, 34, with reference to the Lanka case, that certain factors specific to the context in which Article 15b occurs must be taken into account for the purpose of interpreting the provisions. Accordingly, at paragraph 35, Article 6 sets out a list of those deemed responsible for inflicting serious harm, which supports the view, etc., etc. So the first point is the court accepts that one must read Article 15 together with Article 6. The second point is that the objection that the court has to including general shortcomings in health within the qualification directive, the objection that it has, can only be because it accepts, as the Advocate General accepted, that there must be an actor. In other words, there must be a person or a body who is responsible for inflicting serious harm. And that's why you have the word therefore in paragraph 35. So accordingly, Article 6 sets out a list of those deemed responsible for inflicting serious harm, which supports the view that such harm must take the form of conduct on the part of a third party, and it cannot therefore be simply the result of general shortcomings. So although the court doesn't use the word infliction as many times as the Advocate General, the court clearly accepts the analysis of the Advocate General. The two articles 6 and 15 must be read together, and there must be an infliction of serious harm in order to qualify under the directive. Now, I know that there is no dispute on the facts of this case that there has been an infliction of serious harm, although the issue between us really comes down to when the harm must be inflicted. So the second of my two propositions is a serious harm must be inflicted in the future on return. So can I turn to that issue? This is simply a question of looking at Article 2.2e, which you'll find on MS 459. My lords, the bottom right-hand corner of that page, Article 2 is defines a person eligible for subsidiary protection as a person who doesn't qualify as a refugee, where substantial grounds have been shown for believing that the person concerned, if returned, to his or her country of origin would face a real risk of suffering. Suffering what? Suffering serious harm as defined in Article 15, and as I've just shown, Article 15 must be read together with Article 6. So the serious harm that the Qualification Directive is concerned with must be suffered not at a prior point in time, but on return to the country in question at a future date.
Well, on its face, Article 2E doesn't require infliction, does it?
No, it doesn't, which is why I drew your attention to what the Court and the Advocate General understood it to mean in the Umboj case.
It really has to take its colour from the reading together of the two provisions.
Yeah. And so what you can see from that, what we say is fairly basic analysis. I'll just say 1 minute more, if I may, and then I recognise the time is 1 o'clock. It's because of this that the return of subjective fears that have been caused by the past torture is not enough, because that wouldn't be deliberate infliction of serious harm by an actor in the future on return. Failing to rehabilitate a person wouldn't be enough. Failure and omission wouldn't be enough, unless, as the court says in Umboj, that was a deliberate decision, nor any other sort of failure to act. One can imagine all sorts of duties the Sri Lankan government might have to look after its citizens, but simply failing to comply with one of those duties would not be enough unless there was a deliberate withdrawal or withholding of treatment. So if that's a convenient point, that in summary is the case for the Secretary of State. And after lunch, I'll just deal with 1 or 2 of the arguments made against me.
Thank you very much. We'll resume again at 2 o'clock. Thank you. The court's now adjourned.